Okay. So welcome everyone. My name is Kyra here. I've seen quite a few of you have tuned in. So once again, if you are here, appreciate if you can just type hi in the chat box so we know that you have tuned in to our Affinity live stream. Yep. Hi, Miss Kaching. Nice to see you once again. Okay. Yep. So while we are waiting for others to tune in, appreciate if you can just drop me a hi note at the YouTube chat. Thank you. Okay, Darren, can you hear me?
Yes, I can hear you.
All right. Okay, that's good. Okay, we have a Boon Ao. I think this is Winston, right? Hi, Winston. Yes, nice to see you here. Okay, let's give a few more minutes for other people to come in. So those who have joined us for the last few streams, I really thank you so much for your support. And if you have any questions or any particular topic that you want to find out more from our speakers, just feel free to drop me a message. And we would like to arrange another series of topics for the month of April. Yeah. Okay, so today we have is our seventh episode of our Affinity live stream, and those who have followed us would know that we have covered many interesting topics for the last 3 weeks now. So all the way from AI, how to use cloud AI to transform the financial practice, or even can use the AI tools to improve the efficiency of your own personal financial planning. And then we also cover all the way to Muslim markets and also cover all the way to estate and legacy planning. So today we are very privileged to have once again Darren. Yeah, Darren, you can switch on your video already. Yeah.
Hello,
Okay.
everyone. Good
Can.
evening.
Good evening. Yeah. So Darren, this today is your third live stream, right?
Yes, it's my third live
Yeah.
stream.
That's good. Just want to find out how do you feel so far?
Okay, I mean, live stream is fun. I feel quite anticipative and excited every time it's my slot because I've
Ah,
got a chance to prepare a topic to share, and I've
yeah.
taken materials from some of the works that I've done, which also
Right.
means that I have a chance to also keep getting current information as well as add on to my last deck of information domain. So every
Mm-hmm.
time when the topic is there, I keep thinking, how can I redo this topic in a different
Yeah.
way? And I think that also gave me a chance to try out some of the content, especially today's content is about Beyond the Balance Sheet, which is a very interesting title. And I
Mm-hmm.
hope to share with the audience tonight that it's not just about numbers that we are concerned with. It's just not about assets we're concerned with. Sometimes also beyond the assets.
Yes, yeah.
Yeah.
So yeah, I'm very much as excited as you because every time you share, there's a lot of shocking news that we have never heard of. And also just to give a brief introduction, so this Finity live stream is our objective is very simple. It's just like we want to invite veterans, industry experts like Darren, who has more than 20 years in this industry to really like build a lifelong learning community and share whatever that we have with the community and so that every one of you can benefit and can take this opportunity to even ask questions from these industry veterans. Yeah, so just to let you guys know, we work very hard behind the scene to get all this set up so that people can come in to stream in smoothly, and then all the interesting topics that are lined up so that can at least you guys at who sacrifice your nighttime can really learn something important that can last your lifetime. Okay, so that's all from me, Darren. So when you are ready, the mic is yours.
Okay, then let me just continue from where you left off. Thank you, Kara, for the introduction. And yes, I do agree you worked very hard because we were connecting and trying to get all this set up, and it's not easy. I also have a chance to be part of what I call a very historic opening because I feel this live stream will continue on to become part of the domain assets in future for people to view back how we started all this. And thank you very much. So let me just take it away from here. So for the audience whom just tune in, my name is Darren. Yes, some of you may have heard me the last two rounds. For those who have not, let me probably give an introduction to myself. I belong to Singapore's first cohort of graduates in STEP, Certificate for Financial Services. So this STEP program is organized, of course, worldwide by the Society of Trust Estate Practitioners in UK, a non-profit organization. So that was the very first interaction I have with external education body. Okay, because STEP is worldwide. Of course, that also got me very intrigued. And as a very inquisitive and curious learner, I continue from here onwards. And today I'm a full member of STEP, which means I have a title called TEP, Trust Estate Practitioner. It's like if you are in investments, you would want to continue on to specialize by obtaining your CFA. So the TEP is the equivalent of a CFA, but it's for estate practitioner, estate planning practitioners, okay? And naturally, much more deeper than most of the financial advisors in Singapore, I belong to this particular group that is very niche lah. So I do a lot of trust work. I do a lot of trust structuring work and helping clients to plan for business continuity as well. Okay, so I usually speak on this topic called trust planning. And I'm happy to see that today more and more people are coming to my seminars, which also means that a lot of the people have already been through the will writing talks, which is good because technically will writing is the first start of everyone's legacy planning journey. And the more I see people um, doing what they have already done, the wills in the first few years, last few years, the natural progression is as when the assets gets bigger, they will start to wonder if the will is really good enough. That's why I see an increasing amount of attendees in my talks, because this topic is very niche. I've been engaged by insurance companies, agencies, banks to do talks for them to open up to their high net worth audience. Okay, because when you have cross-border assets in like Singapore, Malaysia, UK, Australia, you really have to think harder than most people who just have assets domiciled in Singapore. So it's with such a direction that I continue to pursue my craft, fine-tune my craft, and that's where I consider myself as one of the few financial advisors, competent cross-border planning specialists. Okay, so yeah, I speak a lot of this topic, and of course, you can find my profile in STEP, Society of Trust Estate Practitioners. So this is my profile. And we are internationally recognized as experts in our own individual fields with proven qualifications and experience. And definitely it's a global professional body with more than 22,000 members worldwide. So nobody can really plan for a client totally if the clients have assets in more than a few countries. So I really call upon my friends in the other jurisdictions to come together when the work requires me to bring them into the picture. So going back to the example that I talked about, if someone has assets in Singapore, Malaysia, Australia, even UK, then what I do is that in some of these jurisdictions, there are tax exposures. So definitely I would call in my UK taxation friend to come in and lend the expertise in guiding the whole planning process for the UK assets especially. Singapore and Malaysia largely have no capital gains tax, no inheritance tax exposure. So we are really wonderfully attracting a lot of people in the world to come and reside here and domicile here. Okay, so continuing from here, these are the practice areas. And tonight, the topic is very interesting. It's called Beyond the Balance Sheet, Beyond the Balance Sheet, which is about legacy and how it's built to last. So many people imagine that estate planning is a very simple situation. It's a very simple thing. So, when death happens, you just check if there's a will or no will. Well, depending on whether if there's a will or no will, then this assets from the deceased just needs to be passed to the beneficiaries. If there's a will, then you follow the grant of probate. If there's no will, you follow the letter administration. So this is the very simplistic outline of what happens. And normally people will just ask the question, so what does the deceased has? And then from here, you continue on. But where are the problems? It is exactly when you have not thought through. So today I'm going to begin this with a case study. And this case study is about young family with children and parents, children and parents, and then these are the assets. So now we are talking about legacy planning and beyond the balance sheet. So let's start with this case study and how do we apply? First of all, I think the first important question is the husband and wife. If there's a death of either husband or wife, my question next is, does anyone knows what to do? If there's a death of either the husband or the wife, what do you think will be the subsequent consequences? Well, of course, it depends on who passes away first. Is it the husband or the wife? Husband or the wife? Sorry, yeah, it's just or the wife. Now you may ask, what's the difference? I will tell you that in most relationships in a family, the husband and the wife, or the father and the mother, they play a unique role to the family. In some families, there's a CFO. Maybe it's the husband, maybe it's the wife, and then the other person is the COO. Okay. And when there's major decisions, then the two of them will sit down and talk about things. So whenever someone tells me that actually death is a very simple thing, you just follow through who dies, whether do they have a will or no will, and then continues to just take the assets from the deceased to pass to the beneficiaries. It's very simple. Then I'll just tell them it is simple because you have no idea how complicated it can be. So today, let's take the chance to examine. Now, if let's say I tell you to ask this question, even to the audience who's viewing yourself, you ask yourself, who in your own family, who is the CFO of the house? Is it you or is it your spouse? Because if the person who passes away first is the CFO, then the remaining partner or the remaining spouse will find themselves in a very, very confusing situation and sometimes even helpless situation. Why is the CFO the first role I ask? Because the CFO of the house usually keeps a very proper accounting-like or Excel-like tabulation of all the assets in the family. So if the CFO of the house disappears, chances are sometimes the remaining person in the family does not even know what assets they have. Well, is this something that is worrying? I believe so, because I've done so many talks. And most talks, they will tell me that, yeah, actually my husband does give me the access, but I also don't bother. You just update. If I want to, I can access it. So this is the tricky part. If you want to, you can access it. What happens if you forgot how to access? So that we will have a big problem. So for people who do not know, passing away, transferring assets from the deceased to the beneficiaries, all needs a certain process. This certain process requires, even if there's a will, requires the submission of this thing called a schedule of assets. And most people today has a very vague idea that this is even needed. It's almost like nobody really knows about this. Even if you've done a will with some legal practitioners, you are even not told about the need to prepare a schedule of asset. But when death happens, this schedule of asset is important. So in a situation, submission to the courts require, if there's a will, the original will. If there's a death cert, the death cert must be there. And finally, the schedule of assets. It looks like this over here, Form 177. The latest form downloaded from the Singapore Family Justice Court. And it says very clearly you have to list down all the deceased properties in Singapore, the amount of money they have, the outstanding debts in Singapore which are secured by a mortgage, which is only referring to property, and the deceased properties outside Singapore. Okay, so this one for deceased domicile in Singapore at date of death. So if you have UK assets, you have Malaysian assets, well, they also want to know the market value as of date of death. But you realize the net estate value is what they really want to know. Okay. When this is not done because the CFO of the family did not really do up a proper schedule of asset, then the remaining spouse will find a lot of difficulty in preparing this in the submission for probate. When this is not done properly, you absolutely have no way to transfer assets from the deceased to the living. So this schedule of assets is very important because how else Are you going to go to the bank and tell the bank that you have the authority to get assets from deceased? The bank's not going to listen to you. I mean, the customer service officer will be nice enough to tell you that you have to be bringing a court order. And this is what they're talking about. The probate is a court order. Even if there's no death, then the administration or the letter administration is the court order. Without these two items, either one, there's no way assets will flow into the estate account. All right. So this is a very important thing. That's why we always say that estate planning is not just about numbers. It's not just about assets that you have. It's beyond that because most people do not even know the relevance or the proper treatment or the process when death happens to anyone in Singapore. How does the court process work? So tonight I want to take this time to explain to you how it works. With doing a will, most people think that it's already done. It's not. A will done without the preparation of schedule asset is just a 50% job or even a 30% job. Without a schedule asset, families face difficulties in taking over the assets left behind by the deceased. And most times, some assets may even be lost. Okay, now, of course, you will say that it's not difficult, what? I can search in Singapore. Well, the search is not difficult, but you must know where to start. If you do not know where to start, then you have to start searching everything. So to someone who doesn't know, like the spouse who doesn't know what the family has, because the CFO of the house kept everything in the head, then the spouse has to really go and search. So going to each and every bank to make an inquiry, and sometimes not even getting a very easy on-the-spot reply back as well. So this is the number of banks in Singapore that is an estimate. This is the number of insurance companies as an estimate. This is the number of investment firms in Singapore as an estimate. Well, if you have really someone who died without doing a schedule asset, can you imagine the amount of work the remaining person, who is usually the executor or the administrator, has to do to go and exactly understand what has been left behind? This is definitely not easy, and this takes a lot of time. One of the biggest constraint in terms of resources is time. Because everyone is super busy and you don't have time to really take on extra job in finding out everything and working through with all the different companies about this. Okay, so of course, that's the first one. If death of the either husband or wife, the consequence will be that the remaining party who is not the CFO will have a big problem. But if the remaining party is the CFO of the family, then naturally, then there won't be a lot of stress because this person will look at the situation and say, oh, now that my spouse passed away, let me continue with the rest of it. So important to know, okay? Whoever dies is important. And we go on to this part because sometimes there's another different version of event. What happens if there's a common disaster of both husband and wife? In this case, then you'll be what? Leaving behind children. And what if I complicate the case study by telling you they are minor children? No longer is it just about transferring of assets. Because now we will talk about another thing called death of both husband and wife. You have situations like in the past, people who whole family goes to Malaysia, but then everyone passes away except maybe the surviving boy. Okay, so these are various articles to remind us that time and time again, we can't control things. In some situations like accidents, for example, sometimes the whole family can disappear except leaving behind one young member. Okay, so if there's a death of both husband and wife, then the next situation will be, who is the guardian? And I've seen many wills, they have appointed guardians, yes, but the guardians, after a few questioning, sounds like they are just maybe trusted members of the family, but may not really know what does the role of a guardianship entails. And in most cases, the guardians take on the role in a very obliging manner because they've been trusted. But do you know this thing? For you as the parent, you not only have to find the guardian, you also have to find the trustee or the executor of your will, if you're going to do one. And you yourself, do you know what the role of the guardians and the trustee are? Because these are people in a very, very trusted position. They are trusted with the children, they're trusted with the assets. And how do you know that you can trust them? For the people whom you appointed as the guardians and the trustees, they sometimes accept the role without understanding fully their obligations and their fiduciary duties. If they know, they really might not agree to the role. Let me give you an example. What are the kind of situation that might happen? So we talk about executors, trustee, and of course, guardianship, right? So here's where I want to bring to your attention some of these things that have happened in the past. This is an example of a guardian who is not good with money management. In 2014, what's left of this family is a widow and having to take care of 4 kids. Do you know that $1 million was almost put together for this family due to charitable efforts by the company? The insurance amount I remember was only 100,000, but about close to 800 plus thousand was raised by charity for this family. This widow who had that much money to take care of the family didn't do a good job of managing the money. In the end, she actually had what I call a failed proper money management. Within 1 year, that whole 1 million was gone. So my question is, whenever you're appointing your guardians for the children, do you know if they are good with money management? If they are not, the monies left behind might easily be lost. These 4 kids absolutely had no idea and were depending on the mother to properly manage the monies raised from charity. But now, everything is lost. So this Madam Mohan is now looking for a job in Singapore to support her 4 young children back in Johor Bahru. Okay, that was in the year 2014. And if you become the guardians and the executors, do you even know what is your role and how do you act well in the role? Because if you are not aware how to be a good executor or trustee, you might be sued by the child when the child grows up. So in this case, in May 2020, this executor of the woman's will and trustee of the woman's assets for the children was actually sued by the child and ordered by the court to pay 87,000. I mean, if today I would dare say most people have no idea their actual responsibilities and their role. And if they have performed it wrongly, they are in a very big liability situation. Okay? Sometimes you really have no idea whom you can trust. And if you choose the right people or the wrong people, there goes everything you have left behind for your child. In this case, this Mr. Tan Seong Chun misappropriated $500,000 by being the administrator of the late brother's estate and having the chance to dip or take away $500,000, 550,000, and to use it for his own usage, personal expenses, and gambling and buying stocks. Who did he steal the money away from? He stole it from his niece. So, like what I said, if you have no idea whom you appoint, then the people whom you thought you can trust came forward to become administrators. They are actually, in a way, well, going to fail your trust. And challenges continues to happen again and again when a natural person acting as executor could be sued by other people in the family because while the will says it in such a manner, the children or the beneficiaries who don't feel that they were entitled correctly may sue the executor to prevent the executor from carrying out the job. So first thing first, it is really beyond just asset management. It is about the choices you make for whom you can trust, when can you trust them, how can you trust them so that they can really take care of the beneficiaries. So please, if you are ever appointed as a guardian, you must ask yourself, do you know what it means to be a guardian and how to be professionally responsible for the role and to be assured you're never going to be pursued in a legal manner by the children whom you took care of when they grow up. Okay, so these are really the problems, and it's just beyond asset management. Okay, but now we have to talk about assets because imagine we talk about this whole family having all these assets. Then you must also understand sometimes people don't only leave assets, they also leave liabilities. So what happens is that in most cases, assets should be more than liabilities. Most people don't accumulate a lot of debts. They therefore are able to put themselves in a solvent position when they're alive and their estate to be in a solvency situation when they are dead, because assets are more than liabilities. So there's enough and positive things to give away. But what happens if the liabilities are more than the assets? Then this is what we call an insolvent estate. So you may have written the perfect will, but before death, you were a guarantor to the company's debts to the tune of, let's say, 2-3 million. Now, at death, just when you thought you really have 2-3 million, your 2-3 million becomes obligated to the company's accounts and maybe have to be even repaying to the banks. In this case, you definitely don't have any assets left. And this is when you become insolvent estate. Insolvent estate means you don't leave behind anything, you left behind debts actually. But in Singapore, the lucky thing is that most debts are already either covered in a way or written off. Okay. What is very sad is that if you have understood this concept about solvency or insolvency, you have taken pains to make sure that all debts incurred in your lifetime are all zero off when you're no longer around. So what kind of debts should be zero off? Number one, mortgage debts. Mortgage debts. Mortgage debts are incurred when a person buys a house or a property without fully paying off. So they have a mortgage loan. It is not surprising today that there are still people who buys investment properties without buying any form of mortgage loan insurance. That only means that if they die in the wrong time, this property may be actually in the red, even after netting off all the potential loan exposure, because the capital value has dropped so much in the bad market. Okay? Now, some of you will have what you call a car. Is a car an asset? Mostly in other countries, a car would also depreciate with age, but not written off the way it's written off in Singapore. So in Singapore, every 10 years, whatever how much you spend on a car will disappear at the end of 10 years. And that only means to say that this car, which comes with a loan, and if you have not settled the loan, it will be a debt. And this debt means to say that you may not even have a car left behind to give to your family. So think of all the different debts that are incurred in your lifetime to make sure that your clients, you, are leaving behind a solvent estate. So property loan, that's one kind. Car loan, that's another kind. Third kind, education loan. Okay, education loan could be incurred as well. Okay, then you have business loans. If you're doing business, then sometimes you have to take on some loans at the start. And then valuables. Some people actually spend a lot of money on taking care of their valuables, like insuring the valuables, or what I call insuring the safe. Well, this is a good idea, but generally, if you have no debts, then your liabilities towards all these valuables will be minimal, because I don't think you can buy any of the expensive watches or loans or anything like that. Okay? Yeah, and naturally, one of the most important thing is zeroize your lending, your borrowing debts. So these are the very tricky situations where I think it's important to highlight over here. The education loan, the business loans, the car loans, the property loans, okay? Education, so these are all the loans that should be zeroized off when a person passes away, rather than to leave it for the family to clear, okay? Up to now, I think I didn't see any questions, but let's keep this continuing on first. Okay, so there are also two groups of assets that I mentioned, and I particularly want to talk about this because properties and company shares. Is it so simple as in just to transfer the properties to the beneficiaries? As what I talked about in the last session, it may not be so simple. Okay, may not be so simple. So Miss Kachin says that I'm appointed as executor for my nephew. Okay, and I totally have no idea what to do. Thanks for letting me know that at least I should know the schedule. I said, yes, Miss Kachin, you're right. Okay. you should at least know the schedule asset. So when you agree to be the executor, in fact, to anyone in the chat group, if you agree to be the executor, you must ask the person, then you must tell me what you have. Otherwise, don't ask me to be executor. Yeah. If not, you make it my trouble, to go around hunting down all the assets you left behind for your family. Okay, so talk about that. Thank you. So, Ms. Kachin, I hope I'm glad you benefited. So, Forex slowly but surely asks, if I've cleared my mortgage, should I stop paying for my term insurance that was intended to clear this debt if I pass away? Well, I'm not going to stop you from paying for the term insurance because I do not know how long your term insurance will last. If you have managed to clear your debt away, as in your mortgage away, you can take it that the term insurance now becomes a different reason for you to keep. It can become another amount leaving behind to give liquidity for a family. If this term insurance is lasting until, I don't know, 85, 95 years old and you're only 60 now, it might make a lot of sense to stop. I mean, make a lot of sense to continue paying for it because that will only enhance the estate value that you have. Okay, that will only enhance the estate value you have. Yeah, so these two asset classes, okay, properties and company shares. How do you intend to give? That's the important thing. As I've covered in my last session, do not make beneficiaries share a property title deed. Don't do this kind of thing. When you do this kind of thing, again, you may have fulfilled the idea of equal distribution, but you create another form of potential disagreement in the future. What if one wants to sell and one wants to buy, and they cannot agree on the pricing? That becomes really a big problem. So like what I said, estate planning is not just about balancing or transferring the balance sheet. What you have goes to other people. No. It's also about how you thought through clearly about how to do things. Okay. Company shares as well. As I've covered in my last session, would you even want to give company shares to a beneficiary who's not even operating in the company? That is something you have to think because time and time again, people have felt the imbalance as the main managing director taking care of the family business and to give out yearly dividend to people who have no contribution is a very difficult balancing of the sentiments. Okay, so I really have some opinion on properties and company shares when it comes to be distributing, and I cover this a lot in my courses that I do. Okay, how I teach the financial advisors, what you should do to recommend to your clients. Okay, so I cover that a lot in my own course, the one-day IVF program that I'm doing for Affinity. Okay, so I do a lot more in detail for this. Next kind of assets, country club memberships, investment in shares. Again, how do you want to give out these two assets? First, if you own a country club membership like a SICC or Sentosa Country Club, these are very valuable country clubs. Their membership prices are today upwards from $250,000. Okay, Sentosa Country Club can range from 400 to 500,000. It's almost like a HDB. Now, how many people can share a country club membership? They can't. So it's best that you think through hard how to give away this country club membership in your arrangements. Who you give to is also important. Why you give to them is also important. And it's just beyond simply writing down a simple line. Because if people cannot interpret your feelings and your logic in why that beneficiary is deserving of this country club membership, then a lot of the chances of mistaken intentions might occur. Investment in shares. Do you know that you can actually hold the investments in shares even after death by your beneficiaries? So actually nothing needs to be liquidated. So you can pass lock, stock, and barrel the whole investments that was done by your clients in their lifetime to the next generation and can hold it all together in a same account as well without liquidation. And this could even be a better way than just to liquidate because every time there's a liquidation of a good asset, I feel very painful. It's like you actually cut short the monetization of these values that could potentially happen. Okay. So now today we do something simple. We do a scenario study. Okay. So this scenario study would be what I want to give all of us a chance to understand how to do this understanding. Okay. What is called beyond a balance sheet. So this is a case study of Mr. R. Mr. R's divorced 20 years ago. he's estranged from his son, who is staying with his ex-spouse since they were divorced. So currently, Mr. R is staying with who? With his mom in his HDB flat, which he owns fully in his name, and his unmarried sister. So his unmarried sister is also staying with him. Well, this HDB flat is worth $500,000, or rather 450,000. Mr. R tells you he intends to give his flat to his mom. However, his mom has her own HDB flat and wonders if his mom can inherit the flat. He also intends to give his estranged son some percentage of his assets, but not his ex-spouse. Currently, the son is 26 years old, so Mr. R only has bank accounts and very little insurance policy in Singapore. Do you all think Mr. R needs to do some form of planning? What do you all think? Okay, yeah. So do you all think Mr. R needs to do some form of planning? Okay, so this is not a trick question, but yes, we all believe that Mr. R should do some form of planning. But in actual fact, Mr. R did not do any planning. Why did I know that? Because this is really not a case study that is fake. It's actually a real case study. So because Mr. R did not do any planning, the grandmother and the grandson tussle over assets appear as the headline for this story. So who's the grandmother and the grandson? Well, with respect to Mr. R, it will be therefore Mr. R's mother and Mr. R's son meeting in court to argue over assets. And the judge dismisses both sides' claim. So what claims were being made? First, the mother of Mr. R wants to lay claims that all the son's asset, which is Mr. R's asset, should go to her. This is her claim. The grandson counterclaimed against his grandma because the grandson found that grandma took away 181,000 from his father's bank account. It's called unauthorized withdrawal. So these are the two claims that the two people make in court. And Madam Rosalinam Lakshmi is already 82 years old and is still very upset about what was stolen from her. That's why she went to court and repeatedly told the judge that my son has told me all the assets will go to her should he die. But the very fact is that Mr. R, what happened to him? Why did he make it happen? Well, Mr. R died in an accident. And that's why when Mr. R died in an accident, this whole program of distribution becomes very clearly understood as what? Following the Intestate Succession Act, which only means that Mr. R's assets will all go to his son, and the mother will have nothing. All I know is that this whole 3 years, from 2019, the year that Mr. R died, to 2022, when this article first came out, two persons definitely did not sleep well. Okay, the son and the mother, because they're suing each other in court. But what can we learn from this? And why did I bring out this case study for tonight? It's because I want to tell you all that actually it's really beyond just numbers and dollars in the asset transfer. Okay? So what can we learn from this case? Number one, from the High Court judgment papers, you will know that the death was due to an accident. So accident is one of those situations that you cannot plan. You cannot plan in advance, and that's why it's called accident. An accident happened so unexpectedly, Mr. R did not even have time to do any planning, so he died without will, and therefore the letter administration has to be applied. But you realize that it took 1 year 41 days for the law firm to help got together this court order called the letter administration. So remember just now earlier in the program, we talked about what is the meaning of letter administration? What is the meaning of probate? In this case, there was no death, so it became the process of letter administration, and it took 1 year 41 days. So for 1 year 41 days, the accounts were all frozen. Can you tell me, is this considered long or short? Is this considered long or short for you? For 1 year 41 days, almost 1 year and 1 month, you cannot touch anything that the assets leave behind. So who are going to be affected? Mr. R's mother is definitely affected. Mr. R's sister is also affected because they stay in the house. But now that you know this house will be lost, because this house actually will belong to the son of Mr. R, so the mother and the daughters and the sisters will all be homeless. So I believe it's a very big impact on them. Okay? Because Mr. R died without a will, he definitely have never done a schedule asset. So what does he really have? Nobody knows. But it took 1 year, 31 days to obtain this schedule asset. How was it obtained? PKWA, which is a law firm engaged by Mr. R's son over here, PKWA, practically used 1 year, 31 days to finally obtain a schedule asset. And only with that can it apply to the court. And then the proceedings revealed that there was a flat, yes. There was also a POSB savings account, 120,000. Wow. There's also OCBC account, about 55,000. There's a co-op account. There's a subscription balance of 50,000, funeral grant of 2,000, and a group term insurance of 46,000. And initially, the last drawn salary was also retrieved as well. So actually, Mr. R is not really so poor, no. He still got 6-figure savings, still got a flat, still got some insurance. But it took 1 year, 31 days for this schedule asset to be obtained. And then after filing it, it only took 10 days for the court to issue. Okay, so that's already very fast. And therefore, you realize the delay is not at the court side. It's mostly at the deceased side. People simply don't know what they bought. And people who are alive doesn't know what the assets the deceased had left behind. So again, this is a form. So you're supposed to fill up the house, the bank account number, how much, the insurance policy numbers, how much, sum assured, your bank deposit, savings, which 3 banks, 4 banks you use, all must list down. So this form, if you do it properly, will be a very good overview of a snapshot of the person's assets at that point in time. Okay? And just in case you want to know, searching is not cheap. If you are not interested to go to every bank, every insurance company, every financial firm to make this inquiry, because it's so difficult and so tedious, you can employ and pay for it. So if there are 100, if you're asking about, if you came to the firm and then you say, I don't know what my uncle owns, but he's died now, I want to collect all his assets. Well, before you can do anything, you have to put a lot of deposits, because every time you make an inquiry, it's $100 per bank or investment or insurance company to go and do asset tracing. So if there are 30 to 40 assets, you are going to really literally pay a few thousands for deposits. All right? Yeah. So at the end, this is all that was discovered. So now you realize, in the end, estate planning is just the mere act of transferring assets to from the deceased to the living. But it's not so easy. At the end of the day, if there were cock up in terms of not having a proper schedule asset, they will cock up when there were no thoughtful planning for what are the lives to be affected when Mr. R dies, the mother, the sisters, then Mr. R has left everyone in a very big limbo situation. And hence, I always urge financial advisors, if you're in the room listening to all this, please remember to do an important job of getting your clients to continually first do a schedule asset, next to update regularly, so that you really will cause less problems for the living beneficiaries to come and apply for all the assets as a administrator. Okay? And if Mr. R has thought through hard enough and planned for the situation where he could be predeceasing his mom, he would have already made in place some arrangements. But the fact is that he has done nothing. Done nothing means that now the mother is a victim of this unexpected death. The sisters are a victim of this unexpected death, and they may have to relocate soon because the HDB flat is going to be given to the son. That's the point blank of this whole situation. At the end of the day, in life, we all talk about when we do our legacy planning, we want to be all doing equally among the beneficiaries. But sometimes equality is not as important as equity or fairness. So in some of the talks early on in the past few sessions, I always talk about how you could help to be more fair than more equal as a basis of doing proper legacy planning. And with that, I just want to take a chance to introduce my upcoming program is on this Leaving a Lasting Legacy, and it's going to be on 1st of April or 7th May. And I encourage you, if you have gained or benefited from what you learned today, last 2 sessions, then you should take the chance to enroll into this program, because a lot more of such things will be told to you. Okay? A lot more such things will be told to you. So my name is Darren. I'm grateful for the opportunity from Finity to come and share all this with you. I'm going to end the session soon. And before I end, I just want to do a few simple highlight. Number one, schedule of set is a very important document. Number two, whom you are choosing to be executors and guardians are very important. Number three, make sure these people also understand their fiduciary role. Otherwise, you throw them a responsibility without telling them what to do. It's a very irresponsible act. Number four, through the whole case study of Mr. R, you realize that planning is not so easy. It's not just about writing a will or not or leaving things to chance. It's also about planning harder. The impact of the sudden demise of Mr. R, what does it mean to the mother who's still surviving him? What does it mean to the sisters who are surviving him? Because now the residence home will be gone. They'll be homeless. So it's really just beyond talking about assets in the balance sheet transferring from left to right. It's not. So in my program, I talk about how to really give yourself, a financial advisor, the knowledge, the opportunity to play a bigger role in your client's life. Why do you want to do that? Because you know that if you serve the client with not just the wealth protection planning, with not just the wealth accumulation strategies, with not just the wealth maximization overview, legacy planning is the last most truthful and noble act that you can provide as service to your client. So my name is Darren. I hope you enjoyed the session tonight. I'm open to questions. I can't see the chat, but if anyone has reached out to Kyra would definitely keep me in the loop. So any questions from the audience, Kyra? Okay, great. Maybe some of you are shy or need a bit of time, no worries. Or maybe some of you are already ready to embark on a learning program because you want to use 2026 as the year of doing a breakthrough in your business. Then I welcome you to start to learn legacy planning from me because I will teach you different ways to open insurance cases in my program. And it is not as hard as you think. The reason why a lot of people have embarked to become an estate planning specialist but no case yet is because they have no idea how to do all the all the work to prepare for the cases to come. Okay? Yeah. So that's what I'm going to have for tonight. Thank you very much for the audience who chimed in today. And thank you for the questions. If there's no other questions, I will not hold everyone back. Have a restful night. Think about what you've learned today. Let it sink in. And if you find that what I've said make a lot of sense, welcome you to enroll into the program I teach. Thank you very much, everyone.
Thank you, Darren. Thank you, Darren. Yeah, thank you everyone for the last 1 hour that you have joined us. I hope you guys have learned something. Yeah, so Darren I really enjoyed your sharing because legacy planning, I really feel that it's not just numbers, but it's really about the people that we leave behind when we are no longer in this world. Yeah, so everyone, I just help me to thank Darren before I end the live stream, and we will be having him for the last series on the 26th of March. This is the last series that we are so proud to and grateful to have Darren to again share with us about legacy planning using as Singapore High Court cases. So please mark down your date, 26th March. We'll have another case study session on legacy planning. And also, you may also push on the notification button so that you can get instant notifications whenever Finity goes live. Yeah, with that said, I wish all of you a restful night. And if you have any burning questions, but you just feel shy to ask us here, you can just always PM Kyra and she'll be able to assist you. Thank you. Thanks, Darren. Thank you.
Thank you, everyone. Good night.
Oh, Darren, there's one question.
Oh,
Yeah.
okay.
So,
Still around.
yeah, still around. So KTV saying he was asking, do we need to list the bank balance in the schedule of assets?
In the proper application to the court, you need to list the balance. In the current situation where you're drafting up your first schedule asset, it might be good to timestamp it and update this every other time with the balance as well. I mean, in between, there's a lot of fluctuations, I understand. Okay, so if you minimally want to do a proper schedule asset, you should at least have the bank account numbers. If you want to be doing a complete job, leave behind the balance. Okay, leave behind the balance.
Okay. Darren, just curious, because sometimes like certain banks they offer a very I would say very affordable will writing. Do you think that this kind of services is worth engaging? It's like just couple of dollars, we can write a will already.
Okay. If you know what you want to plan, go ahead. The reason why these platforms are set up is for people who knows exactly what they want, and therefore this will be helpful because the way the crafting, I believe in all those platforms are there already. I don't think there will be grammatical error. I think all will have the wills formalities followed. But yet again, most people do not know what they don't know. It's like
Mm.
if you go to a gym, if you're already a trained physical gym practitioner yourself, then you know exactly what to do with the weights and how to keep track. But some people go to the gym, they don't know what to do, so they try to copy what other people do. So if people are doing reps, like 30, 40 kg, you also copy, but you don't understand why they use this weight. Then you may not
Mm.
have done the proper training for yourself.
Yeah.
So likewise, take all the wheel writing platforms as a reference. But think again, if you don't even know what you don't know, then how can you even plan?
Mm. Mm.
Yeah, if you don't even know that joint accounts have to be spelled clearly, you wouldn't even list down a joint account in those will writing platforms.
Mm. Yeah, got it. Okay, thank you so much. I think, Darren, you have given us a very clear direction on how to proceed further with the legacy planning, but I'm sure you have more to share during your course because we can't cover everything with this 1 hour. Yeah, so everyone, thank you once again for tuning in for the last 1 hour. If you have any questions, just feel free to approach us. Thank you. Thanks, Darren.
Thank
Thank
you,
you.
everyone.
Thank you,
Good
everyone.
night.
Good night.
Bye-bye.
Bye.